Good afternoon and welcome to today's webinar where we're going to be discussing common claims under construction contracts. I'm Michelle Litteken and I'm joined by my colleague Jacqueline Unger, and here's our contact information. We're part of the Government Contracts Group here at Polaro Mazza. As you probably know, Polaro Mazza is a full-service law firm. We have offices in DC and Boulder, Colorado. You can follow us, find out all kinds of information on our website about all the different practice groups we have to offer. So today, we're going to be talking about a couple of different things, all pertaining to REAs and claims. We'll begin with a discussion about the differences between requests for equitable adjustment, also known as REAs, and claims under the Contract Disputes Act. We'll also be talking about the potential basis for REAs and claims, best practices for preparing and submitting REAs and claims, and strategies for working with the government and subcontractors as you're going about these efforts. Now Jackie will talk about the differences between REAs and claims.
So, some brief points about REAs versus claims as a little overview. An REA is a request for compensation, which can be in the form of time, money, or both. That's based on changes, suspension of work, or other factors that may arise during contract performance. An REA is filed as part of the contract administration and negotiations between the parties, but it falls short of a claim in the procedural requirements and formality because it's not as formal as a claim. It's part of the negotiation process rather than a more formal dispute. And the claim, on the other hand, is a written demand seeking the payment of money in a sum certain, the adjustment or interpretation of contract terms, or other relief arising under or relating to the contract. A claim is filed under the Contract Disputes Act, and it's a formal dispute that can end up with litigation. Going into a little more detail about REAs. An REA may be submitted anytime during contract performance or closeout, but generally not after the contract has ended. The contractor typically should assert its right to an REA within 30 days of the change that gives rise to the REA. But this isn't a hard deadline. Failure to provide the notice within the period will not bar the REA unless the government can show that it was prejudiced by the failure to give notice within that time period. REAs are based on a FAR or contract provision that provides for an adjustment of contract terms. This can be the changes clause or differing site conditions are two examples of that. There's no particular format required for an REA, but we typically will form the REA as a letter to the CO with exhibits attached which provide the support to prove that you're entitled to the time or compensation. It details the change to direct cost markups, the time to complete. You want to include as much detail as you can to support the REA to make it more likely that the CO will actually grant it. The government doesn't actually have to respond to the REA, which can be a reason that the REA might become a claim. And importantly, in an REA, preparation fees are recoverable because it's considered an aspect of contract administration and negotiation before there's actually a dispute between the parties. So as part of your REA, in addition to the increased costs of performance or time that you're requesting, you can also include your legal and accounting fees or internal costs that make up that you incur in preparing the REA. One other thing is that REA doesn't have a certification requirement that the REA is accurate and made in good faith, except for DoD contracts if the REA value exceeds the simplified acquisition threshold.
Okay, now we're going to turn to some basics about CDA claims. And I'll say if you have any questions as Jackie and I are going through these slides, feel free to submit them. We should have time to answer them at the end and may be able to answer them as we go. So the CDA claim must be filed within 6 years after the claim accrues. That's a jurisdictional requirement, and the agency can't agree to waive that in any way. So 6 years is the firm deadline, and the clock starts when the contractor has begun performance and started to incur those additional costs. The law recognizes that you may not know what your costs are until you've actually finished performance and been able to get all of your costs in from your suppliers and subcontractors and whatnot. But the clock does start ticking when you begin to incur those costs, or you find the differing site condition, or the constructive change happens, which we'll be talking about what all those things are. So the contractor must provide the contracting officer, the CO, with notice of a claim prior to final payment on the contract. And the claim should be filed within 30 days of cancellation of a stop work order. So there are 2 additional deadlines to keep in mind. No particular format is required for a claim. It typically takes a form of a letter to the CO with exhibits, much like Jackie said an REA does. And it must constitute a clear and unequivocal written statement that gives the CO adequate notice of the basis and amount of the claim. The relief may be compensation or an adjustment of contract terms, or both. And that adjustment of contract terms includes your extension of time in the period of performance. The FAR outlines a couple of specific requirements for a claim. It needs to be a written demand or assertion, so you can't call up the contracting officer to assert your claim. You need to put it in writing. A claim can be made by the prime contractor or the government. Most often a government claim will be a termination notice or a demand for money back. We won't really be talking about those concepts here today, but those are 2 potential claims that you may see. Hopefully not. Seeking relief to which the contractor or the government believes it is entitled pursuant to the terms of the contract clause or due to a breach of contract by the other party is the 3rd element in the claim. So that's where you say, I believe I'm entitled to X dollars or X number of days because, and that's your entitlement based on a FAR provision or the contract. Claims seeking over $100,000 must be certified, and here we've given you the magic words that the government is looking for. They want you to certify that the claim is being made in good faith, that the supporting data is accurate to the best of your knowledge and belief. And as I said, your numbers can change as the process moves forward, and you can revise your claim, but you should believe that the numbers you are submitting are accurate to the best of your knowledge. And you believe the government is liable, and the person who certifies the claim must be authorized to act on behalf of the contractor. It doesn't necessarily need to be the president or the vice president, but anyone with the authority to bind the company.
Now we're going to go into some of the common bases for REAs and claims. So first, differing site conditions. This is addressed in FAR 52-236-2. A differing site condition must be an actual physical condition of the job site, must be a condition that existed at the time the contract was executed, and the condition must not have been discoverable during the site inspection. So with respect to the contractor will be deemed to have knowledge of whatever would have been reasonably discoverable during the site inspection. But a reasonable site inspection doesn't require that the contractor undertake an exploratory investigation to discover latent defects, meaning it doesn't necessarily have to go behind walls or do an investigation of subsurface conditions, and it doesn't have to, a reasonable site inspection won't be deemed to include something where the government prevents you from actually performing that site inspection. But otherwise, it's important to actually undertake a site inspection so that you are aware when you're bidding of what the conditions actually are. There are 2 types of differing site conditions. The type 1 conditions are where the conditions that the contractor, the conditions that are encountered are materially different from the conditions indicated in the information about the job that are provided to bidders. And the information provided to bidders, the contract documents, this is interpreted to very broadly. So it can be documents that are mentioned in documents provided to bidders. So there is a kind of a broad take about what that will include. Let's see, and then the second type 2 conditions are where it's unknown and unusual condition that differs materially from what is ordinarily encountered on the particular type of work in that particular locality. So this is where you, regardless of what's actually in the bidding documents, what you're told the conditions will be, you encounter unusual conditions for the area. So it depends on the locality, and it's important to know the specific type of conditions that are normal for the area where you're doing the work before you bid.
Okay, our next topic is delay claims. Now, there's multiple types of delay, and your ability to recover depends on the fault and the impact. So you may be able to recover time and potentially damages depending on who is at fault and what kind of delay we're dealing with. So the first kind of delay here is an excusable delay, and that gets you a time extension or compensation depending on, once again, fault. Compensation really depends on fault. So excusable delays occur when it's beyond the control of the contractor, without the contractor's fault or negligence. It's unforeseen prior to bidding. So some examples here are owner-initiated changes, unusually severe weather, strikes, wrongful acts by government, acts of God, like I've dealt with fires and floods for different situations. Now, unusually severe weather is weather that is abnormal compared to past weather at the same location for the same time of year. And you need to be able to show the weather had an adverse impact on critical work. If it's pouring outside but all of your work is inside, it's going to be harder to show that that weather affected your ability to perform. Some contracts will contain a contract clause that sets a standard based on historical trends, where there's blanks that you fill, that either the government or the offeror fills in for how many days of snow there are or how many days of rain, and that sets the baseline. And if you experience more than that, there's a presumption that a delay occurred. One thing to keep in mind here is concurrent delays. That's when there's a second independent delay occurring during the same time period. That can limit your ability to recover if the government says, well, you said there was weather going on, but you were also delayed because you didn't submit your 30% design on time. And in that case, a fact finder is going to look and see what was driving the critical path, what was actually preventing the work from being done, and that will determine how much delay is recoverable. To improve your chances of recovering for delay damages, you should document every delay that occurs and keep track of weather conditions. You should give notice whenever there's a delay impacting your work, and you should update your schedules. I know I've been in situations where contractors say, I'm trying to get the job done. I don't want to stop and, paper everything. But having those updated schedules and having documents showing what's going on will really help you in the long run. And we received one question about whether you need a time impact analysis as part of an REA or a claim. And we do often encourage the time impact analysis. Sometimes if you have a good in-house scheduler, they can prepare them. We've also worked with experts to help prepare them, and they can add some credibility and make it less of a he said, she said, and add another voice in support of your claim. Some delays are non-excusable. That's when the delay is foreseeable or preventable by the contractor. That could be financial difficulties, supplier delays, if you could get the supplies from another source, defective specifications where the defect is apparent prior to signing the contract. That for those, the government saying, hey, we're not accepting the risk of you having problems. If you're slowing the work down, that's not our fault. So that's why they're considered non-excusable. A time extension will be granted only when the contractor proves the event caused delay to overall completion of the contract. And that's the idea of the critical path. If there's something going on that's tangential to the main purpose of the contract, it's harder to show that that delayed your completion. And as we said before, recovery may be limited if concurrent delay affects completion of a project. In many cases, it's possible to apportion the delay and break out the part that's subject to the concurrent delay and isolate the part that's driving your claim. So it doesn't prevent recovery. It can just potentially lessen the amount you're able to recover. And delays can be linked to other claims, like Jackie mentioned, differing site conditions. Those can cause delays, and you would want to be able to show how the differing site condition caused the delay. And that would often be a compensable delay, where the contractor is entitled to compensation plus time extensions because the delay is the government's fault. So that can happen with a differing site conditions or another type of claim, or it can happen under the suspension of work clause, which the FAR site is here, and that's when the government directs you to suspend work. There can also be a suspension of work without that FAR clause in your contract, and to recover there, you need to show the government was at fault. For example, the government breached the implied duty to cooperate. And then we also have constructive suspensions, and that occurs when the government doesn't directly order you to stop working, but something happens in the course of the project that prevents you from moving forward. So that's why it's viewed as a constructive suspension. That happens oftentimes when there's a delay in issuing a notice to proceed. There's a delay in the availability of site, like if you're working in a dormitory or something on a military base and the people who are living in that dorm are not out when they're supposed to be. That would be a constructive suspension. Or other things that are interfering with your work, like delaying approvals, delaying inspection. And there, you should advise the government of the event causing the delay within 20 days. Like Jackie said, for a lot of these things, the notice period is not always strictly enforced if you can show the government wasn't prejudiced, but whenever you can, you should always be giving the government notice, especially in delay situations, because they can step in and hopefully get you the project back on schedule. Now, in terms of recovery for delay, you may be able to get your indirect costs that occurred during the extended performance period. There's unabsorbed home office overhead that occurred during the extended performance period. That's subject to the Echelon formula, which is complicated. It could be a whole separate webinar in itself. In a nutshell, it's a formula that determines the overhead attributable to the delayed contract. So instead of your whole company's overhead, it's the portion of the overhead related to this contract. You can get your material cost increases that occurred during the delay, lost productivity, and other damages directly related or attributable to the delay.
So next, defective specifications. So the contractor is entitled to compensation for increased costs of performance when it follows government-provided defective specifications. So the government has a duty to ensure that the specifications it provides are adequate for the task at hand and are reasonably accurate. And if that turns out not to be the case, then the contractor is entitled to compensation. So there's the difference between design and performance specifications. Design specifications are those where the government states the specific materials to be employed and the manner in which the work is to be performed, whereas performance specifications, the government just provides the ultimate objective, and it's up to the contractor to select the means and methods for achieving that objective. It's only for design specifications where the government is stating the specific materials and methods to be employed, where that implied warranty exists that the specifications are accurate, and that's where the defective specifications, REA, or claim is possible. So it's important to understand that you're not going to be entitled to your costs if your own, on a design build, your own architect gives you defective specifications, then you can't get any recovery from the government. It's only when the government is providing you with those specifications that have a problem that you can then recover from the government. And then changes. So this is the big one that encompasses some of these other bases that we're talking about under FAR 52-243-4. The contractor is entitled to equitable adjustment if a change in the contract work increases or decreases the cost or time of performance. And there are a couple different types of changes. So the most obvious one is directed changes, which is where the CO makes a change within the scope of the contract. So the CO just goes to the contractor and says that it wants performance done a different way, and you incur costs because of the changes that the CO is making, then you can recover those costs. Alternatively, there are constructive changes where the contract work is changed by government action or orders without following the specific procedures of the changes clause. So the government hasn't invoked or necessarily intended to make a change where it's agreeing that you might incur costs and that it'll cover those costs, but there can be a constructive change either through implicit or explicit government acts. A constructive change requires work beyond the contract requirements and either an order or fault by the government. So this can include disagreement as to contract requirements. If the government is saying that the contract required one thing and you believe that it required something else, and the government is then telling you to go forward with its agreement, its understanding of the contract requirements, then you could argue that there may be a constructive change there. Based on that disagreement that you have. Constructive changes can also consist of defective specifications, acceleration of performance when the government is requiring you to move up the schedule, or failure of the government to cooperate, or hindering your performance in some way. For changes, so it's important to recognize who has authority to order a change. It can't just be made by any government personnel. It can only be made by the CO or a formally designated representative of the CO that can order the change or constructive change. So it's important for a contractor to pay attention to who's actually directing the work and not to agree to perform assuming that you'll be paid if the change in performance somehow impacts your costs. Not just assuming that those costs will be covered by whenever any personnel directs you to make some change. So you need to make sure that the change is actually authorized by the appropriate personnel. And then again, with the notice requirements, you need to assert the right to an adjustment under the changes clause within 30 days after a written change order, or 20 days for a constructive change. And as we've been saying, these aren't necessarily strict unless the government can show some prejudice, not necessarily strictly enforced.
Now we're going to get into some best practices for preparing and submitting REAs and claims. One of the questions we've received so far was about the difference between PCOs, proposed change orders, potential change orders, and REAs. I've seen other people use different terms for these kind of things. As long as you're submitting a request to the government to change the terms of your contract or give you compensation for the work that you've performed, that would fall under the umbrella of being an REA. So all of those things are subject to the rules that an REA would be subject to, which aren't many rules, as we've discussed. Just, the best practices and the fact that if it's not adversarial, there are costs you can recover, which we'll be getting into here. So, should you file a claim or an REA? We generally advise clients to file an REA when you have a good working relationship with the agency and the government has indicated a willingness to reach an amicable resolution, or where there's a need to show contractor willingness and good faith to negotiate. You do not need to file an REA before filing a claim. So if you know that the contracting officer is not your friend and disagrees with you, that's when it makes sense to start out with a claim. So you file a claim if there's animosity or a clear indication that prior discussions, correspondence, the government does not believe you're entitled to an equitable adjustment. Before making the decision to file a claim, you want to avoid references to the matter as a dispute. That is because there is a line in being able to recover attorney's fees, consultant fees, etc. in preparing your submission. If you're in a dispute, those costs are not recoverable. If you're not in a dispute, then it's considered more of a matter of contract administration, and you can recover those costs. So because you can convert an REA into a claim, we will often advise clients to put together a really well-supported REA, use attorneys, use whatever consultants you need. If the REA gets denied and you're not in a dispute situation, it's pretty easy to then convert that into a claim. You just have to add the magic words at the beginning referencing the CDA, add the certification if it's over $100,000, request the contracting officer's final decision, and you've got a claim. As Jackie mentioned a little earlier, you need to know the limits of the government's authority when you're putting these things together, because you need to know who has the authority to bind the government, like the contracting officer or a formally designated representative. You'd want that designation in writing if you're acting on directions from the Corps or the COTAR. This is because if you start submitting documents showing that the PM told you to do something or some other government employee but not someone with the authority, the government's probably going to reject that and say, that person who told you to do that work or, to build that extra wing on this building, whatever it may be, didn't have the authority to do that, and we're not required to pay you. So if anyone other than the CEO is telling you to do something, look for the designation in the contract, see if that person has been granted that authority. If it's not in the contract, there must be a separate writing, like a letter or, some kind of memo coming from the agency.
We can't overstate the importance of building the record. Documents can be essential in supporting the claim or REA. You don't want to just create your REA or claim without the backup documentation to show that you're actually entitled to the cost or the time that you're requesting. So backup documents don't necessarily have to be formal. It can consist of email or correspondence from the CO who's directing the out-of-scope work or the changes to the requirement, or regarding different interpretations of the contract, for instance. Can include the schedule updates to prove delays. So as Michelle had mentioned earlier, important to update the schedule and then provide that to the agency. It can consist of receipts and invoices and internal records to support your claimed costs. You can't just come up with a magic number for the costs that you've incurred. You do need to have the backup documentation to show that those amounts are valid. And then photos to capture differing site conditions or provide evidence for the work performed. The photos can be helpful as conditions change over time, so you want to make sure that you have the evidence for what was going on at the time of the change to verify that when the REA claim is eventually filed, which can be much further down the road. Let's see, okay. And then watch out for waivers and releases. So you want to watch out for waiver language before you sign any contracts, modifications, closeout documentation with the government. It's easy to overlook this language. It can get lost along the way in all of that fine print that the government gives you to look at, but it's incredibly important because you can lose your rights through this language. The government often includes waiver language in its contract modifications, which releases the government from any liability for any action or inaction prior to the modification. So this can bar your recovery in a claim where you're basically releasing the government from liability for whatever the basis of the claim was. If the release language is unambiguous, the contractor more than likely is stuck with the plain and ordinary meaning of the release. An executed bilateral modification that contains no reservations constitutes an accord and satisfaction, saying that you are representing that you've received, that basically you're giving up your rights. So if you believe you may have a claim, you want to add your own language to the release to make clear that you take exception and are reserving those rights to file the claim in the future, and describe the reserved issue. It doesn't have to be exact. You don't have to have be specifically clear or have the specific amounts of the costs that you've incurred, but you need to be specific enough to put the government on notice about what the future claim is, or what your claim might be.
For example, if you had encountered differing site conditions and finding asbestos in the building you were working on, you could carve out in your waiver that you're releasing all claims except for those relating to the asbestos found, on the second floor.
So here we have a couple examples of releases that you might come across similar language to this. So the first one shows these adjustments are in accord and satisfaction and constitute compensation in full on behalf of the contractor and his subcontractors and suppliers for all costs and markups directly or indirectly attributable to the changes ordered herein, of all delays related thereto, and performance of the changes within the performance time so stated, which gives up your right to go after these costs. And then under the second one, we have the contractor hereby remises, release, and forever discharges the United States, its officers, agents, and employees of and from all manner of debts, dues, liabilities, obligations, accounts, claims, and demands whatsoever in law and in equity under or by virtue of the said contract, except, and note that there's that ability there, as we're talking about, to write in any claims that you have. So make sure that you take advantage of that and put the government on notice there, reserve your right by writing in your claims. Otherwise, you can see that this language is incredibly broad and really is intended to release everything.
And I think it's worth noting the first one incorporates costs that your subcontractors or suppliers may have. And we've seen cases where a prime contractor isn't aware of any claims, or it's content with the compensation that it's gotten for any costs that it faced, and it signs this kind of release. And then a subcontractor submits a claim. And once you sign this, you can't go after the government for your subcontractor's claim. You may be on the hook if the subcontractor is able to show that it's entitled to recovery. So it's a good idea before signing these, even if you think you're okay and you don't have any claims, to check with your subcontractors and make sure you're all on the same page, and have your subcontractors be signing similar releases when they're getting paid or getting modifications to help protect you. So now we'll talk about using experts and consultants. And this could be in a claim or an REA context. You want your claimed amount to be calculated based on reliable principles and methods. So that's one way that using an expert can come in handy. the government can bring fraud claims against you. It doesn't happen that often, but when contractors submit claims they do not believe are true or accurate, or they play a little loose with the numbers, you're opening yourself up to liability. So you need to be careful here. So using an expert to help you nail down those numbers is good practice. And that's, as the second bullet notes, you're certifying that this claim is accurate if it's over $100,000. So that's even more incentive to make sure your numbers are accurate. In the case of litigation, a third-party expert or consultant or an expert within a company should be used for calculating delay damages. As I said, we've used experts for that purpose. You don't want your attorney doing that because your attorney could be a witness then and have to testify, and an attorney can't really serve both roles at the same time.
I'd also note that experts can be useful for example, differing site conditions, for
defective specifications,
for explaining what the actual normal situation for the location is. So it's not just the cost, but also like the legal basis of the claims.
Mm-hmm. Like we had a differing site conditions claim where the contractor found a lot of mold, and we had an expert that was a mold inspector who said, yeah, when you encounter this kind of mold, you do need to put up plastic sheeting, you do need to seal everything up, you do need the protective equipment. And that, once again, adds a voice of credibility and authority to your claim, and it's less of a he said, she said, because you're able to bring in a credentialed person to back up what you're saying.
Now we're going to talk about some strategies for working with the government and subcontractors. So first, for subcontractor claims, the subcontractor cannot submit its own claim to the government because it doesn't have contractual privity with the government. So if the subcontractor tries to submit a claim directly to the government, that's just going to kicked out. It's not going to go any further. Instead, the claim has to be submitted through the prime contractor. The prime contractor must clearly and affirmatively agree to sponsor the subcontractor's claim. The prime contractor, in doing this, the prime contractor can't just pass through the subcontractor's claim. It has to adopt it as its own instead. So it can't just say, here you go, CO, here's the subcontractor's claim. You need to have clear language showing that you're sponsoring that claim as your own if you're the prime contractor. FAR 44203C allows a subcontractor the right of indirect appeal to a board of contract appeals or the Court of Federal Claims.
In rare circumstances. It's not a very oftenly invoked provision.
Okay. And let's see, in the appeal of Binghamton Simulator Company, the appeal was dismissed because the subcontractor did not ask and the prime contractor did not agree to sponsor its claim. And but the right to appeal was granted in the subcontractor. Although the right to appeal was granted in the subcontract, that wasn't enough for that claim to actually go through to the government. So we recommend that you address the sponsorship in any subcontract agreements. If you're the prime contractor, then less may be better. The prime contractor needs to maintain the ability to decline to submit a claim if it cannot be submitted in good faith. So as the prime contractor, you don't want to agree that you'll submit any claim that the subcontractor has. You don't want to be bound to what they come up with. So you would want to try and limit that in the subcontract agreement. As shown in Binghamton, a boilerplate provision giving the subcontractor the right to take over a claim or file an appeal does not constitute a definitive agreement by the prime contractor to sponsor a particular claim. So that won't be enough on its own. So as the subcontractor, you want to have language in the subcontract and mechanisms that are designed to require the prime contractor to provide a clear expression of its sponsorship of a claim. So you don't want to have the ability for the prime to just say that it will only pass through your claim to the CEO, because that won't be enough for the claim to go through. So you want to try to have more specific language in there about what the prime contractor is required to do to make sure that you have that clear and affirmative agreement that they will actually sponsor the claim, to make sure that you can have the claim be addressed by the government.
And it's also a good idea to spell out who's going to be bearing the cost of this. If it's the subcontractor's claim that the prime is willing to sponsor, the subcontract will often say the subcontractor is going to be responsible for all of the costs. And you often want to spell out what's going to be done with an appeal, because submitting a claim is the first step. If the contracting officer denies it, then you may want to appeal it. Once again, the prime will usually want to have some discretion on whether to do that, and you definitely want to address who's going to be paying for that appeal, because it can get expensive.
And one more thing, with the certification requirement for sponsoring subcontractor claims, the prime contractor is going to be the one that must include that certification when the claim is over $100,000, even though it's sponsoring the subcontractor's claim. The prime contractor is making that certification to the government, so the prime contractor will want to include a similar certification from its subcontractor in the subcontract.
A liquidating agreement is a great tool to use when a prime contractor is going to be sponsoring a subcontractor claim. Now, this is often used for pass-through claims. A pass-through claim is when the subcontractor is doing something, on your contract, and they are incurring a cost because of a government action, like the government changes the scope of work, that changes the sub-scope of work, or maybe this subcontractor is responsible for lead paint remediation, and you find out there's more lead paint on the site than there was before. That's a cost the subcontractor is incurring, and you'd want to pass that on to the government so you can recover and you're not on the hook for it. So what a liquidating agreement does is it liquidates the liability of the prime to the subcontractor. It provides that if the subcontractor is owed money and the prime is responsible to pay the sub-owned, but only to the extent that the prime recovers money, if any, for the subcontractor's work through settlement or disposition of the claim against the government. What this means for the prime is if you prosecute this claim in good faith and try to recover on behalf of your subcontractor, and you don't recover, or you don't recover as much as the sub wanted, you're not going to be on the hook for those costs. So it's a good way to limit the prime's liability. It can also be done if you're submitting a claim for the prime, but there's subcontractor costs included in it. Like if there's a differing site condition that's affecting everyone on the team, and as the prime, you're rolling up those costs into your claim, you may want to consider doing a liquidating agreement, because if your claim isn't successful, the subs could be suing you for breach of contract or withholding payment and whatnot, and the liquidating agreement would help protect your interests. There are some terms that need to be kept in mind, because under the Severin doctrine, a contractor cannot sue the government for costs that it's not actually going to be liable for, because then there's no point of the government paying you, because there is no actual damages. So you don't want to just draft up a liquidating agreement on the back of a napkin. You need to consult with counsel and make sure that you're addressing these kind of considerations. Working with the government. One of the questions we got is that this contractor has had several REAs sitting with the Navy for approaching a year. I've been in those shoes working with clients. That's often a point where you want to just convert it into a claim, because the government is not required to respond to an REA. But if you have a good relationship with the government, it's good to start with the REA. You don't want to wait until the last minute to submit an REA or a claim, because it can hold up contract closeout, which is only going to frustrate your customer. So it's better to, as soon as you've gotten a good handle on your costs, submit that REA or claim. Be patient up to a point. When you submit a claim, the government, unless it's a smaller value, but most claims, the government has 60 days to issue a decision, or tell you when it's going to issue a decision. So if you just submitted your REA a couple weeks ago, you're probably not going to have heard from the government. You need to be patient for a bit. But if you're at the year point, 8 months, 6 months, you may need to, step it up and convert that REA into a claim. You can get past roadblocks sometimes by reaching out to third parties to help you. For instance, if it's a small business set aside, the SBA or the OSDBU in the respective agency can be of assistance. We've had some clients have luck involving members of Congress who will, reach out to people within the agency and say, hey, my constituent's having this problem. They submitted an REA. What's the status of that? You can also try to work with allies within the agency. We can't say it enough. The contracting officer is the one who has the authority to deal with these things. But if you have good relationships within the agency, you can leverage those and say, hey, we haven't gotten a response. Do you know what's going on? Could you talk to the CO? You can copy these people on your submission so they know what's going on. We often will also request a meeting with counsel. Sometimes you can avoid a lot of, bureaucracy and the government having to write things out by just requesting a meeting, fleshing these things out, and trying to negotiate a solution. You should be responsive to requests for additional information. The government will often be looking at things and not understand where costs are coming from, not understand how things are being calculated. So just be looking out for those and respond in a timely manner. As I said, you often be in a situation where you have to decide when to convert that REA to a claim. It may be time pressure. It may be that you will, need the funding and you can't wait anymore. The government may also want you to convert your REA to a claim. This gets into the weeds, but the government gets funding from different sources. And once a contract has gone on for a couple years, those funds may be in prior appropriations, and they have to go through a lot of hurdles to get to them. There's also that once you get into claim world, the government can access funds in the Justice Fund and other sources, and they're not limited to just their budget for that contract. So they may want you to convert it to a claim just so they have more flexibility in how to pay you. Okay, well, we have time to answer. We've gotten a bunch of questions here. So feel free to send some in, and we will try to answer all the questions we've gotten. One question was, how about changing documents by the client as the project evolves? In other words, a new set of documents that alter what we construct. These project documents do change. And if the government's providing you with new drawings and saying this, that would be a change, and you could assert a claim under the changes clause. Here, the important thing would be to show that you're incurring extra costs or doing additional work. If all the drawing is doing is like moving a cabinet from one side of the room to the other, and it's not causing you to incur extra costs or not require extra time, that's going to be a harder claim to win on. But the government giving you new drawings, new designs sounds like a good basis for a changes claim.
As long as it's the person with authority who's directing that change. So again, as Michelle was saying before, if it's just a project manager that isn't designated with the appropriate authority, then you need to go back and make sure that you have the person with authority, the CO or designated representative, actually order that change, and don't agree to do the work or don't do the work until you get the properly authorized change.
And we have another question about elaborating on defective specs that are apparent from prior to signing the contract. I mean, I've seen some crazy examples where a diagram shows 4 inches when it should be feet. I mean, those kinds of things are on one far end. Then you get more into gray area where it's like, would a reasonable architect, a reasonable designer been able to tell this angle wouldn't work, or outside the construction context, whether like this machine that you're building, that gear isn't going to be able to function in that way or the temperatures won't allow X to happen. So those are the kind of things when you're looking at the specs, if it would raise someone to say, wait, is this going to work or is this seem defective? That's the kind of thing that you'll have a really hard time winning on if you wait until you're in the midst of performing. Okay, and the formula for calculating overhead, we've got a couple questions about that. It's called the Eichley formula. It's EICHELAY. It's a 3-step process. If you Google it, you can find lots of resources about it, or if you want to talk more about it, you can contact us afterwards. And then another question was, is it used on calendar days or work days? And unless you have a very generous government agency, they're going to want you limiting that to work days, because you'd only be recovering overhead normally for your work days. On holidays and weekends, if you wouldn't normally be working, then you would normally not be able to recover those costs. Another question is, does the COR have authority to issue changes? They might. As we said, look at your contract, see if they've been delegated the authority. When in doubt, if the contracting officer's representative is asking you to do things, it's not a bad idea to say, hey, I want to do what the agency wants me to do, but do you have authority? Should we be talking to the CO about this? Because we understand that you want to be a good contractor, you want to get along, you don't want to create problems. But if you go and do this extra work, you don't want to turn around and not get paid for it. So it's just good to get all of this documented, try to communicate in writing when you can. That's authority. You want it in writing. Sample language for a liquidating agreement, we can't hand out. I mean, it's usually a couple-page document. If you want to talk about preparing one of those, you can reach out to us and we can take steps to do that. One person started 3 minutes late and wants copies of the presentation templates. The presentation's available on our website, and we also have a whole YouTube channel, which this webinar will be on, and there's lots of other webinars. A couple of years ago, I did a webinar with one of my colleagues on terminations, which is something you may face on a construction contract, and that was part of a 2-part series. Another one was on REAs and claims, and got into some of these concepts, and then other things like how the appeal process works. So those are 2 that you may want to check out on our YouTube channel. These rules do apply to 8A sole source contracts, because these are just FAR provisions that apply to most contracts, and a lot of these are from the case law and just how you need to present things and support them, and that applies across contracts. Okay, another question is, would unanswered pre-bid RFIs be an example of apparent defect specs at contract signing? Not necessarily. The government sometimes does not respond to requests for information. You would really want to have someone very knowledgeable in the field be able to look at that document and say it was defective or not to begin with. Another question, during the waiting period between submission of an REA or time impact analysis and government response, the task order has expired. Can the government require the contractor to continue working after expiration of task order period of performance? We're currently working at risk. It's risky, as you said, to perform without a contract in place. If you haven't finished the work, the government would, and they're not willing to pay for an extension, the government would normally do a no-cost extension. That's definitely something you would want to document, because the government shouldn't be accepting services without a contract in place. There's actually rules against that. So that is a tricky situation. If you'd like to talk about that more, feel free to reach out to us. I can only provide brief answers here. And it looks like a lot of the questions we're getting are very fact specific, so we don't want to get into too many of those here. Well, it looks like we've answered all of the more general level questions, and if we have not gotten to your question, we will follow up with you in the next few days, maybe early next week with the holiday coming up. So thank you for joining us today. We hope you enjoyed this webinar and found it to be useful, and we look forward to hearing from you and working with you. Thank you very much.